Good afternoon, everyone. On behalf of the Center of Asian Legal Studies, I extend a warm welcome to our speakers, colleagues, friends, and guests from universities and legal practice from all over Asia and beyond. We're celebrating with this roundtable today the recent launch of an important book edited by our Professor Andrew Harding and Professor Munin Pongsapan from our partner university, Thammasat. I'm very pleased that we have the editors and three distinguished speakers here today. These speakers are Dean Nata Kongcharoen from Chiang Mai University, Professor Thongchai Winichakul from the University of Wisconsin-Madison, and our own Professor Kevin Tan. I'm looking forward to learning about legal history in Thailand today in this coming hour and a half. And I would now like to invite my colleague Kevin to guide us through our discussions of today's event as the moderator.
Thank you very much, Christian. And ladies and gentlemen, thank you very much for joining us for this very important panel discussion on a new book, Thai Legal History, edited by Andrew and Munin. I'm Kevin Tan, and I will be the moderator, and I will also be one of the commentators in this panel. We will begin by inviting the two editors of the book, Andrew and Munin, to give us a short presentation on the highlights of the book, after which I will then invite the commentators to give us 10 minutes of comments each, after which we will get a response from the editors, and then we will throw the session open to all the participants. Now, for those of you who are not quite familiar with the Zoom format, for questions and answers, we will be using the Q&A format. In other words, there's a Q&A button at the bottom of your screen. So please feel free to include this, to tap on this and type your questions in. I will try my best to curate the questions and then sort of direct them to the correct respondent at the end of it. If you want to address a question to the panel generally or to the editors, you can just leave it as such. If not, you can say this question is intended for so-and-so. All right, so with that, let me invite my dear colleague, Andrew Harding, and my former teacher to come in and address us on the book. Andrew, please.
Thank you so much, Kevin, and thanks to the Center for Asian Legal Studies for organizing this event. Thank you, Christian and Suguna and everybody, and Diraj and everybody else who's facilitated this. And thanks, Kevin, for your opening remarks too. And your mentioning that you were my student really puts me in a certain age bracket, doesn't it? But anyway. So there are just a few brief comments really to make about the book. I'm very keen to learn what Professor Thongchai and Ajahn Nuthamon are going to say about it. And thanks also to all of you out there for attending this, and we look forward to your questions and your feedback as well. So during these few minutes, I just want to do two things. I want to talk about how the book came to be written, and then I want to say something about the intellectual approach and the structure of the book. And I will then hand over to my dear colleague Munin, who will then tell us more about the original contributions that we hope and reckon that the book has made to the subject of Thai legal history. Excuse me. So going back, I can't remember how many years it is, but it's a few years to the original conversation. The question came up between myself and Munin, why there seemed to be so much work being done in English on Thai legal history, but none of it seemed to be getting published. There is, of course, quite a lot of work in Thai on Thai legal history. And but there seemed to be also a lot of people working on the subject and doing things like writing PhD theses in English on Thai legal history. But how to get this work published, that was really the puzzle. So we went through a number of kind of possibilities and decided that all of them were not terribly promising. And so then we came up with the idea that what we needed was really something like a big fat book, which would set out a number of areas of Thai legal history and would secure contributions from as many people as we could get. And so Munin asked me to take the lead editing this book. And of course I said no. And that's why I finished up doing it, because anybody who knows Munin will know that he doesn't take no for an answer. And so the no had to be rapidly converted into a yes. And that's something I don't regret at all, because it's been an incredibly creative and very pleasurable experience with contributions from 20 people in the book itself, not to mention the enormous contributions made by people who are not specifically listed as authors, but have helped us in the editing process. And I want to mention particularly Lasse Schultz and Adam Riki and Bill Roth, and also they are all at Thammasat University, and also our friends and colleagues at Cambridge University Press, Joe Ung and several others who have done an absolutely fantastic job producing a very large and very complex book, with Thai script and so many issues to deal with. So that's how it came about. And I think if you look at the contents, you'll see that about 2/3 of the contributors are Thai scholars, and about 1/3 are non-Thai scholars who are nonetheless experts on Thailand in one way or another. And one thing I want to mention straight away is that I'm incredibly pleased and really proud of the fact that we have managed to provide an opportunity for so many younger and a few mid-career Thai scholars to publish their work at the highest possible level with Cambridge University Press. And the quality of the work that they produced, even in the very first draft, before we had even discussed it, was absolutely outstanding, and also written in extremely good English. You might imagine that there was a huge language editing issue to deal with. Not really. They'd done an absolutely superb job, and I'm really proud of all of them. I think that the interest of their work and the quality of the points and the writing has been absolutely uniformly superb from beginning to end of the book. So in the introduction to the book, I sort of posed the question, why are we interested in legal history? And we might sort of parse that as, why are these particular scholars, who are mainly but not entirely legal scholars in Thailand, so interested in legal history? This is going back to our initial conversation on this point. Why are young scholars in particular so keen on writing about legal history? And I think that's an interesting question. I'd be glad to get input from others on this, but it seems to me that what they have noticed is a kind of a large gap between law and society in Thailand, and going back obviously in Siam, speaking historically. And I think from what I know, Ajahn Nuthamon is going to talk a bit about this law and society aspect. I mean, she is a law and society scholar, so that's what I would expect from her. So I think they have been driven back into history to try and sort of find the answers to questions like, where does all of this law come from? What kind of a thing is it? And how do we explain the very obvious gap between legal and social understanding of law? And so much as it is a book about Thai legal history, it's also a book about Thai law and society. And I think that is a key to understanding a lot of the work that you will find in the book. So we can see aspects of legal change, and we can see aspects of particular legal problems that have arisen, which appear to be rooted in history. That doesn't prevent these scholars from talking about the present, and even in some cases talking about the future. So I think we can see a very long sort of span of legal history in the book, and a very broad approach. I will come back in a moment to talking about the structure and the different periods that we're looking at. But I just wanted to give one example of what I'm talking about. And we're hoping to mention, by the way, all of the chapters in the book at some point during the next few minutes. And this is the chapter by Kongcharoen and Nuthamon, where they have addressed a very interesting issue, which is the concept of civilization in 19th century international law. And this is extremely important to understanding legal change in Thailand and the whole reform process of the late 19th and early 20th centuries. And it also deals with Thailand's position in the world. Obviously, they're talking about Siam in the 19th century, but I think it would be very difficult even now to understand the relationship between Thailand, modern Thailand, and the international community and international relations without understanding the very long 19th century background of this phenomenon. So that's just one example, but I think almost all of the chapters could be cited as an example of this historical approach. So coming on to the structure of the book, you will notice that it, like Caesar's Gaul, it falls into three parts. There's the first part, which is on the pre-modern law. And then there is the second part, which is about the reforms, the civil law change that I mentioned. And then the third part is directed towards the mainly the constitutional struggles of the 20th century, even right up until 2017. So I think the last legal document that is mentioned in the book, or the latest, is the 2017 Constitution. So it brings you right up to date. So there are these three periods, and with the title, from traditional to modern law, you might expect that what we are trying to do is to present a process of evolution over time. This is not really quite how things have turned out, because I think when we look more closely at the chapters, what we find is that they have an approach which in the introduction I've described as holographic. In other words, they can see the present in the past, and they can see the past in the present. And I think that's something that is true of really all of the chapters in the book. And one sort of, I suppose, the most extreme case of this holographic approach is Peter Leyland's chapter on administrative law, where rather than giving a sort of sequential chronological account, he has approached the subject from a conceptual angle, describing particular aspects of administrative law and how they have changed over time from the 19th century right up until relatively recent public interest litigation on environmental law, which is a very sort of contemporary topic. Another very striking example of this, I think, is David Engel's chapter on the blood curse. This is the chapter in glorious, gory technicolor, describing how the protesters, the red faction protesters, spread blood over the gates of public buildings and other places, and he explains this in terms of something that is very ancient and traditional in the Lanna kingdom legal consciousness, which is this idea of the blood curse as a way of sort of accusing your opponent. So starting with something very contemporary, David Engel goes right back in history, even to pre-Thailand, pre-Siam, talking about the Lan Na kingdom and its very distinctive legal culture, which is very, very different from what we now know of as central and southern Thailand. So we find that a number of these chapters, although falling within a particular third of the book, are nonetheless addressing periods that lie outside it. I mean, a very obvious example would be Kongsacha's chapter, which looks at the initial royal commands, and that goes from the earliest times right up until the accession of King Rama X, relatively recently. So turning to the, I'm going to leave Munin to say more about the first two sections of the book and the chapters there. And I want to just in the few moments I've got just to talk a little bit about the third section, which is the one that talks mainly about constitutional issues. So the chapters by Rawin Lillapatana and Henning Glaser, between them give a very, very interesting and extensive account of constitutional struggles from 1932 right up until 2017, so that we can get a sort of conspectus of the issues that Thailand has been trying to deal with from a constitutional perspective throughout this period of almost 100 years. In addition to that, we've got a chapter by Tyrell Habercorn, which looks at the issue of immunity clauses. And this is an example of taking not a particular area of law, but a particular legal provision. Eugénie Mériot does the same thing with the lèse-majesté law, and looking at it through time, through different periods of discussion. And then also in this section, there is Duncan McCargo's chapter, which relates a particular episode, and here's another approach to legal history, where he looks at a particular controversy in judicial history. So here he's focusing on an institution and a particular episode rather than an area of law like contract law or criminal law, as Munin will be talking about shortly. And then finally, not in this section, but I want to refer also on the subject of the judiciary to an extremely interesting chapter by Surachada and Adam Riki, which talks about the subject of British judges in the Supreme Court of Siam in the first half of the 20th century. Now, I didn't even know when we started that there had been British judges in the Supreme Court of Siam. And this is all based on recently examined archival material, and we can expect a lot more information and analysis from these two researchers, we hope in the future. But it's a fascinating study that raises all sorts of questions about legal influence and legal transplantation and so on, when you find British judges deciding cases involving Siamese litigants in the Supreme Court. And you'll find that gradually over time, they sort of adapted themselves to Thailand's civil law system. In one of the earlier cases, the British judge actually cites an English case while deciding the issue, which is very odd, to find in Thailand's civil law system. But they learned quickly and decided a vast number of cases. This is not a marginal effect at all. Just to conclude, I think I will concede that our coverage in the book is not absolute in terms of periods of time or topics. This is only a beginning. It's, we're not trying to seal up the subject in any way. It's only a beginning, and there's an awful lot more work to do on Thai legal history. But we hope that we've given the subject a boost, and that other scholars will take this over and produce a lot of very, very interesting work. And I'm delighted to find that Professor Thongchai is not only here, but also, he has recently pivoted towards legal history, not in time to be included in our book, unfortunately, but at least we can have the benefit of his future work and his comments on the book. Finally, I just wanted to mention two developments that might help us in this direction. One is the recent establishment of a new journal, Thai Legal Studies, at Thammasat University, and Munin and I are very proud and happy to be the chief editors of that new journal, and our first issue is going to come out very, very shortly. In addition to that, we now have a Nation Legal History Association, which was established really by Dr. Winichakul and Chris Roberts at Chinese University of Hong Kong, Dr. Bui now at Oxford. This is a fantastic opportunity to take forward legal history work, not just on Thailand, but on the rest of the region. And, it's interesting, since the book came out, I've had many comments and questions from people across the region saying, wow, that's really a great book. We should have a similar book on our country. So, let's have books on, on Malaysia and the Philippines and China and Japan and Korea and other countries around the region. That would be really great. So with that, I want to offer yet again my sincere thanks to everybody and to my wonderful colleague Munin, who has been so incredibly supportive of this enterprise. Even providing funding for our seminar that we had in Bangkok, which was a really great event to support this the production of this book. And so over to him, Ajahn Munin. Thank you.
Thank you very much, Andrew. First of all, I would like to thank our friends at the Center for Asian Legal Studies for giving us an opportunity to present our new book. But the biggest thanks we have to go to Andrew, who pioneered this project and led it to the successful publication of the book. There are many more highlights and original contributions of the book that I would like to add. Let me start with a chapter titled Thammasat, Custom and the Royal Authority in Siam's Legal History, co-authored by prominent historians, Dr. Chris Baker and Professor Pasuk Pongpaichit. This chapter shed a new light on the relation between the Thammasat and Rajasat, the two essential parts of traditional Thai law, which developed from ancient Indian law. It has been long believed that the Thammasat played the central role in traditional Thai law, and the king has limited legislative power to enact royal decrees known as Rajasat only to supplement the Thammasat and within the scope of the Thammasat only, due to a long-held concept that a ruler has no power to enact law. The author's conclusive evidence showed that the role of Thammasat was exaggerated to suffice Thai kingship with Buddhist morality. The authors instead offer reinterpretation that in old Siam, the king was a legislator, and royal legislation was a key institution of the Siamese state in the pre-modern era. There is another chapter which supports Chris and Pasuk's main thesis. It is titled The Influence of Buddhism and the Ancient Siamese Legal System from Ayutthaya to 21st Century. It is authored by Dr. Kem Thong Thonsakul Rungreung, a constitutional law expert. The author submits that traditional Thai law was deeply rooted in the concept of Buddhist kingship, which assumes that the king is a giver and protector of law, justice, and order. And therefore, his decrees are deemed inherently in accordance with Dhamma. The author also proves that the influence of Buddhism in Thai law remains strong despite the modernization of the legal system. There are two other chapters which provide historical accounts of concepts relating to kingship in Thailand. The first chapter, titled The History of the Initial Royal Command, a reflection on the legal and political context of kingship and the modern state in Siam. This one was authored by Kongcharoen of Thammasat University. According to Kongcharoen, an initial royal command is the first speech that the king delivered to the public during the coronation ceremony. The author contends that the initial royal commands illustrate the adoption of Hindu, Buddhist, and regional theories of kingship to justify royal legitimacy and prerogative of Siamese monarchy from the Ayutthaya era to that of Bangkok. The second chapter, titled A History of Thai Lèse-majesté Law, was written by Eugenie Maria. The author gives a broad historical account of Thailand's most controversial law, which has ruthlessly been enforced and led the prosecution of dozens of young people over the past few years. The author argues that the Lèse-majesté law is not to be understood as a standalone piece of criminal legislation, but is considered in Thailand to be the very implementation of the constitutional status of the head of state, namely his sacredness. There are 4 chapters which explore foreign influence in the modernizations of Thai law. Khanapol Janhom of Chulalongkorn University, in his chapter titled The Modernization of Thai Criminal Law from the 1908 Penal Code to the 1956 Penal Code, explore the modernization of Thai criminal law before concluding that the reception of foreign criminal law in Thailand is a successful legal transplantation. On contrast, in my chapter titled The Fundamental Misconception in the Drafting of the Thai Civil and Commercial Code of 1925, I prove that there is a fundamental misconception among the draftmen of the code about the influence of German law in the making of the Japanese Civil Code, which resulted in the blindly copying of the German and Japanese civil codes to make the Thai Civil and Commercial Code. And I contend that this greatly affects how the code has subsequently been interpreted. Surachada Riki and Naran Pathanachai co-authored a chapter to give an historical development of trust in Thai law. It first appeared in the Thai Civil and Commercial Code, but was removed from it some years later due to its incompatibility with the civilian nature of modern Thai law. However, in recent years, the concept of trust has reappeared in Thai law, but this time it is limited to a specific business. Lawyers start to wonder whether the concept of trust would soon have a larger role to play in the Thai legal system and return to the Civil and Commercial Code. And the last chapter that I would like to introduce to you is written by our young colleague, Pinop Atipibunsin of Thammasat University. It is titled The History of Thai Family Laws, Strong Women and Weak Gender Equality Under the Law. The author, although it appears that Thai women have a relative strong status in both traditional and modern Thai law, contend that there are still many problems with the gender equality in Thai law. So I hope that a quick glimpse of the highlights of the chapters will stimulate your appetite for the full text. And thank you very much for your attention.
Thank you very much, Andrew and Munin. I think they've given you a very, very good idea of the impulses that led to the writing of this book and the various chapters. So with that, maybe I can now invite Nata to give her comments first.
Thank you very much for the thorough explanation about the book. So I'm very honored to be invited as one of the panelists to read and provide the feedback from the book. Actually, I'm the follower to Andrew since 2001, and I took the course of Law and Society in Southeast Asia. So my My outline of the comments will be have 3 points. First is the landscape of the Thai legal history, and then my feedback after I read this book, and then also it tends to be the continuing studies from this book. First, the landscape of the Thai legal history. Because of I am the legal scholar, so I'm not so keen about the tools from the historian perspective. So I use the comparison from the previous studies on the Thai legal history. So I look at the English literature in Thai legal studies. From the for the English legal world, I found that the Southeast Asia studies on the law is quite very limited, not mention the Thai legal studies. So I have 2 books that I think it have the fundamental on the Thai legal history. First is the M.B. Hooker that have one of the chapter in his book on the Southeast Asia legal history. And then this book also quite similar to the first part of this book about the when we mention to the traditional law and its modern. So the mainly on the Thammasat and Manu Sarajan from the South Asia influence in the Thai legal context. And then also another one is from Tamara Luz that I think is very outstanding about the subject Siam. And also after that, the work on the family law perspective from the Thai history studies. And then when we look at the Thai literature that I divided into 3 groups of ideas that I compare with this book. The first one is the general legal studies. So I call it as the fundamental Thai legal studies. For example, the book from Ajahn Kittisak Pokati, and also others like the fundamental piece from Rolanka. And then after this fundamental Thai legal studies, which mainly focusing on the legal text, we have recently the work from Ajahn Thongchai, Winichakul, that I got the concept from his last year book on the legal privilege state and the loyalist rule of law, which I think is quite the eye-opening for the Thai legal studies. And also from my colleague Thongchai Prisha Silapakul, that he mentioned about the legal historiography, that the textbook on the legal history mainly is from the legal historiography perspective. So from this literal review, as I would like to draw my feedback after I read this book. First of all, this is very outstanding. I would say it's the textbook that with the thoroughly, it's not only the legal text that mostly the fundamental Thai legal studies used to be, but it's also the context from the law and society perspective that I expand from the study in law and society in Southeast Asia. This book expands into the legal history in the Thai society. It has very thoroughly aspects from horizontal and vertical vision. So from the horizontal, this book provides variety dimension. First of all, for the general codification from the Thai civil and commercial code, as well as the criminal code, from the history of the drafting and also the misconception from the process that we transform from the traditional legal system into the modern legal system, as well as the vertical that mostly I found that this book from the first part, it still have the so-called royal nationalist ideology that it seems inevitable that we are previously in the absolute monarchy and also the Thammasat.
Nata, can you wrap up in 3 minutes, please?
Okay, and then also from this is the vertical perspective that mostly the law as the before the modern era, we have the law as the monarch decreed. But then later on in the part 2 and part 3, this is for me is very outstanding with the young scholar and very critical. So I'm very happy to read the part 2 and part 3 as the critical perspective and very thoroughly deep into each topic. Then also, I think the left out that it can be continuing study from this book. First of all, I think even though we have the first about the British judges in the Supreme Court, but I still cannot see the thorough of the legal, procedural, and the legal system as an overview. The book has also the administrative court or administrative procedure. I think I still want to see the legal system on the kind of the previous, the pre and the post-modern era of the Thai legal context. And then the last one is the law school and the legal professional that I think is quite still lacking from this book. So this is all of my comments. Then we can have the discuss later. Thank you.
Thanks very much, Nata. And now let me invite Prof. Thongchai to offer his comments, please.
Thank you. First of all, we're very welcome to a new publication on Thai legal studies, legal history, because new monographs and collections in this field are quite infrequent. As Andrew said from the beginning, I'm not sure on the back cover of the book, it says it's the first one. I'm not sure it's the first one, but I'm pretty sure that it's among the maybe less than 10. I mean, there are not that many books on legal history in Thailand, especially the ones that are not directly related to current issues. I mean, in recent years, there are a number of articles and book chapters related to Thai legal history, many of them because those historical dimensions are important to understand the current issues. So this book, the majority of articles in part 1 and part 2 are not directly related to current issues. Part 3 maybe, they are, but the majority of the articles are not. So this is a rare case that these articles are compiled, are collected in one volume. Okay, perhaps because of this, Thai legal history, this book, the title book, or I would call TLH, does not pretend to focus on a coherent theme or substance, which normally would be considered not good for publication. Instead, it does the opposite, addressing a variety of subjects in this small field. Okay, although there are some downsides of incoherent theme or subject, I think it is the right approach for this book for the benefit of the field at this time. If trying to focus so much narrowly on particular subjects, perhaps you cannot find that many articles. And I think the purpose, as Andrew suggested from the beginning, is more like not just launching the book, but relaunching the field, calling attention to the field in the broad sense. So I think it's the right approach to try to try to cover as many subjects as possible. So the collections cover ancient legal doctrines, Buddhist and local legal ideas, both public and civil laws, constitutions and coup orders, administrative justice and gender equity, and more. Chronologically cover traditional laws and legal culture in pre-modern time to the modernizing reform in the late 19th to early 20th century, and the constitutional and legal crisis since the mid-2000s to the present day. I am a novice in this field, having turned my attention to the law and legal system in science seriously only in 2018, 4 or 5 years ago, less than that. Since I know something about Thai history, I assume that my task that Andrew and Ajahn Munin expect me to say, to look more for this book, to look more at this book is to look at history, the H in the title TLH. Okay, I will do so. I will focus on the history side of this book. I divide into 4 observations. My first observations, given the variety in this compilation, in this collection, we can find different kinds of history, conventional, uncritical, and critical ones. We can find the one that is part of the narrative, clearly shown in the narrative in the article, and we can see history being unspoken premise in several chapters. I mean, they mention history in passing or in general, but in fact, it is a premise for the analysis for many articles. These different histories do not necessarily contradict one another, but they are different. I wonder, however, if the authors are aware of the implication of particular historiography they rely on, and in some cases, the possibility of different outcomes if they take history more critically, and if they assume a different history as a premise of their analysis. I will clarify this point shortly. Second observation, the studies of recent political legal crisis, I call recent crisis, not just political, but in the context for our talk here, I think it is political legal crisis because legal matters are very much at the heart of the conflict of the fightings in Thailand today, not just political. Many articles in the part 3 about constitutional conflicts, about legal aspects of the royalist regime, the Thai-style democracy and democracy with the king as the head of the state. The article make an acronym DKHS. So get used to it. And chapter 6 by Muriel on lèse-majesté law. These studies have been historicized. The articles on this issue has been historicized pretty well. They often take Buddhism and cultural methods into consideration as well. Perhaps I would say that I would note this point because the argument on these issues in Thailand often focus on more legal technical issues. Some, but not much, look at historical side of the article of the cases. But in this book, and I see some articles before this book, they try to trace back and historicize the issue. So I think articles here historicized pretty well, perhaps thanks to the previous ones published elsewhere, such as by Russell, Harding, Peter Leyland, and David Strickfus. The serious issues, however, the political legal crisis, these issues should lead us to examine the fundamentals of Thai legal system and jurisprudence and the systemic problems. However, constitutional crisis, abuse of security laws, and unjust judiciary are taken primarily as political issues in Thailand, and to some extent, to great extent in the articles in this book too. They are taken as political issues or as politicization of the law and the system that otherwise, without being politicized, they are okay, they are in good condition. Therefore, there is limited scrutiny into the jurisprudence. I mean, these hot issues, the serious issue, the past 15, 20 years are taken as politicization of the laws and political issues and have not questioned as much that this is probably the fundamentals of the Thai legal system or the problems in Thai jurisprudence itself. People have not questioned this far. And I would say this is the way I would like to see. Only chapter 16 by Glaser engages some extent with the Thai jurisprudence and the implications. The legal system and jurisprudence are not yet taken up for serious scrutiny in similar fashion that Nick Chisman does in case of Burma in his book 2015, and Jyoti Raja does in her book in the case of Singapore in 2012 book, in which they took at history and identified the particular characteristics of the legal system in those two countries. My personal take on my interest in legal history is I follow these two examples. I think the issues, the conflicts, the serious issues that happened in the past 10, 20 years are much more fundamental than we thought. And I would rather, I try to look at the question, the foundation of Thai jurisprudence. I would say the approach would be similar to Chisman and Jyoti Raja have done in their works. The third observation, back to the book, the conceptual frame and premises of the scholarship on the beginning and foundation of modern legal system in Siam has been little changed. Again, I say it again, the conceptual frame and premises of scholarship on the beginning and foundation of modern legal system in Siam has been little changed since the seminal work by David Engel in the late 1970s in English, and since Prince Damrong in the 1920s in Thai. Many articles in the TRH in this book, likewise, uncritically assume the conventional historiography of the modern Siam and of the modernization reform under King Chulalongkorn. So the conceptual frame based on the conventional history of the modernization reform under King Rama V. Historians have been very critical to this historiography in the past 20, 30 years, if not longer. But it seems that the field of Thai legal history has been immune, relatively immune from the critical historiography. Let me clarify this on 2 points. One, many articles in Thai legal history take the notion that Siam is not colonized and the reform self-independence of Siam and so on. These are uncritical and outdated cliches. Many articles in this book and in the field are to base their analysis on this uncritical historiography. If the semi-colonial Siam in any connotations of the term is taken more seriously, the legal reform would probably look quite different, such as the way Tamara Luz in her book in 2006, Nuthamon mentioned a moment ago, Subject Siam. She has done and demonstrated the gender dimension and the pluralistic characteristic of the legal reforms. These findings could have been missed if the conventional historiography is taken for granted in her book. Critical historiography of this period suggested the other side of the reform, which is the unspoken process from the point of view of the Bangkok elite, namely the effort to maintain Siam's imperial power by transforming the Thai state into modern absolute monarchy, modern absolutist state. Modern technology of the state was adopted and employed effectively, such as creation and management of territorial sovereignty, colonial-like administration, modern bureaucracy, modern transportation and communication, especially railway and telegraph, and of course, the centralized, modernized legal system. Again, conventional legal history would take this as a measure, as a mechanism, as a way to self-independence. I wouldn't deny that. But conventional legal history doesn't look at the other side of the same process, which is to maintain the former imperial power over the former tributary vassal of Siam and to consolidate the former imperial power in the form of the modern state. So a continuation in the form or in the discontinuous form of the state. The two sides of the same coin, reform, self-independence, and reform to consolidate and maintain the imperial power, have different implications conceptually and methodologically. That's all I can say. The longer version of this I will put in the review that I promised Andrew and Munin that I will write it out. The second point on this conventional history that is uncritical is that modernization theory is underlying the conventional historiography of legal reform, explicitly and implicitly. This is also the case in many articles in part 2, and also other parts as well, but mainly in part 2, take the underlining many historical premise is the modernization theory. But again, I will not talk about this point here. I will write it out in the review of the TLH to be published, I think in the journal, right? I talked to Andrew later because I finished the first draft, but not finished the final draft yet. On this point, suffice it to mention that the narrative of, in chapter 12 of Apinop on gender equity and chapter 13 by Peter Leyland on administrative justice are very interesting because they do not fit the conventional narrative of legal modernization. I'm glad to see that. And in this case, it's obvious in the narrative. No, I'm not taking that legal reform, modernization narrative. I take a different one.
Sorry, Thongchai, can I have you wrap up in maybe 2 minutes?
Yep. Fourth observation, final one. The successful legal modernization in the conventional legal history also rests on certain notions of pre-modern legal tradition in Siam. For example, it rests on the idea that Theravada kings have limited legislative authority, primarily due to the limit set by the cosmic Prathamasat or Dhammasatra, and limit by the 10 royal virtues, keeping those feudal kings from becoming legal tyrants. But in the conventional history, legal reform was rather a clean break from the past. The new legal system is a secular. After all, it was produced by transplantation from Europe, mainly by European advisors and drafters, and recognized by European powers. The traditional and Buddhist legacy from the seems miraculously minimal. Legacies minimal, frictions minimal. Perhaps because of this notion, most studies in Thai legal history do not give enough attention to the religious and cultural dimension of the modern system, with the exception of David Engel's recent book on thought, custom, and karma. All articles in part 1 of this book challenge these notions, if not shatter the clean break. This is also, I like, probably a bit biased or a bit favor because I love pre-modern history. Even though I myself, I teach it, I myself have limited ability to do research, but I love that. So part of this book challenge this notion that it's a clean break, the notion that the king have limited authority, the notion that the king didn't create many laws, so on and so forth. Kem Tong in chapter 5 argued convincingly that the idea of Dharma is pervasive throughout the legal system, in the court and how to interpret and enforce the laws, in the principle and practices of the judiciary, and in the two fundamental concepts of the entire legal culture, Jutitham and Nititham. If words matter, perhaps Thai jurisprudence and legal system is not as secular as we assume, and the notion of justice and rule of law are not the same as we have taken for granted. Perhaps scholars should take Engel's approach to examine the rule of law, customs, and traditions in the main legal system and in Thai jurisprudence as well. Judiciary could be institutional nexus that many of these things that we talk about converge. It could be an area that we can unpack about judiciary to observe Thai legal history in action. Unfortunately, there are only 2 chapters in the book, in TRH, on the judiciary, and their focus and the focal issues are specific cases that doesn't engage with history as much in the way that I have discussed so far. Overall, I'm excited by this volume. I found legal history is fun for investigation. I really hope that this volume finds many readers who share excitement with me. Thank you.
Thank you. Thank you so much, Thongchai, for a very, very thorough review. We really look forward to reading your written review of the book. I was very happy to give up some of my time to the other commentators because I think you have said a lot more things that I already wanted to say. So, you know, as the final commentator, I only want to touch on very few points insofar as the book is concerned. First of all, of course, I'm not a Thai specialist. I know very little about Thai history other than, you know, the basic stuff. My comments would be primarily on things like the scope of the book, what it tries to do, and maybe agenda for future such volumes. First of all, 3 things that I absolutely love about the book and which has been highlighted already. First of all, I think the coverage is really very interesting. And as Thongchai has said, you know, maybe it was a good idea to have this as a collected volume rather than try and fit everything into some kind of a more holistic and sort of a methodologically correct form, because this is something that you can dip into from, you know, you don't have to start from page 1 and end right at the end. And it is a very huge book. And so it is one of these books that's really presents a wonderful smorgasbord of topics which allow you to tap into them. The second thing that I love was the ability of the editors to bring together both, you know, sort of experienced senior scholars as well as junior scholars. This is incredible work and, you know, something that augurs well for the future. The third thing has to do with the approach of the book and what actually legal history is all about. when I studied legal history a long time ago in the last century, it was a very boring subject for the most part, because traditional legal history as taught in sort of the English tradition is a history of doctrine. And so there are only that many articles one can go on about, say, the doctrine of consideration or the development of the law of assault or things like that. And so, you know, if we are going to make history a lot more interesting to people who do law, whether they be legal scholars or political scientists or even historians who may sort of venture into this field, I think what they have done in this book is to widen the scope of what counts as history. And the historicizing of current events, which Thongchai refers to, is a very, very important part. If you look at the structure of the book, very often a traditional sort of legal historian will look at it and say, hey, come on, no, part 3, this is not history. I mean, you know, when Chou En-lai was famously asked about his assessment of the French Revolution, he said, well, it's a bit too early to tell. Well, this is starting from 1932, so this is really way too early if you had that particular approach. But I think by looking at events of today, making that history relevant to the issues that we are contending with is something that is much to be admired for. Is there anything that I don't like about the book that I could ask for more? Well, there's one that I always thought could do better, and we could all do better. It's hard to have a history book with lots of people, lots of places, and no pictures. You know, really, come on. I mean, we could have Pridi and Pibun and all these guys here. Well, that one is just one, but, you know, maps, you know, and here I'm thinking of Thongchai's brilliant book, Siam Mapped. And actually something that could be done as, in fact, a complement to that wonderful chapter on Siam and the standard of civilization, which is maybe someone might, you know, in another volume, look at the sort of the legal creation of the territory of Thailand, of modern Thailand, and how Thailand acquired the boundaries and borders that it now has, and so on. And yet that's another topic for investigation. So, you know, with that, I'd like to say once again, congratulations, Andrew and Munin, for a wonderful book. It has been great reading it. I wish the font were a bit larger. I wish you had more pictures, but otherwise, a wonderful book. Congratulations. So may I now invite you both, you know, either one of you or both of you to maybe respond. I haven't seen any questions in the Q&A yet, so you have some time to respond.
Munin always likes me to go first, so
please, Andrew. Thank you very much.
I'm always the flag catcher, you know, and then he falls. Anyway,
I'm learning from.
I want to thank all three of you very, very deeply and very gratefully for absolutely fantastic comments on the book. And you know, there are so many good comments that I've heard in the last few minutes that it's really impossible to respond to this in the sort of time frame that we've got, especially as we want to kind of get questions from the audience. Yeah, I mean, just to address, and I don't mean to marginalize, you know, any of the comments, but obviously I can't address all of them. We can't address all of them in the time we've got. But I think that they're very useful indeed. I really look forward to Professor Thongchai's review, and it sort of occurs to me that it might even be a good idea to have a seminar just on this subject, because I think you've raised so many interesting issues, not just relating to the book, but in relation to the entire field of Thai studies and Thai history and Thai legal history, that, you know, I think we need a much larger exercise than today to sort of unpack those issues and discuss them. And I do take seriously the point that is made about critique of Thai legal history. And I think that's a very important direction in which to take things in the future. I mean, I think there is criticism in the book, but obviously we're at a stage of development of the subject, at least in English, where we need to sort of lay down, first of all, what the actual facts are. You know, and that in itself is not terribly an easy job, because there are so many areas that are not written up. There is a chapter on literature review, very sort of basic chapter to indicate the sources. But I think what you get out of that is the fact that, you know, we really don't have very many sources to deal with. And to be clear, this was, you know, not, I mean, it's not the first thing, of course, ever written on Thai legal history in English, but I think it was the first attempt to provide some sort of a reasonably comprehensive picture of it. It's still, of course, by no means comprehensive, but we attempted to make it as comprehensive as we could. There are many areas of law that are not dealt with. I think particularly on the pre-modern law, and even before your comments, Thongchai, you know, I would have said, yes, the major area that is not really sufficiently covered is in the pre-modern period, where I think there are lots more questions that can be asked. And, you know, I mean, it's very clear that these chapters have, in a way, overturned the apple cart when it comes to the pre-modern period. So I think there's a lot to pick up and a lot to think about, a lot more questions to ask about, you know, the substantive law. And yes, Nata, the legal system. I mean, we need more work on the institutions and the practical impact of those institutions in society, not just in the contemporary world, but, you know, going back through history. And this is something where I think the historians can help us a great deal, because I'm not sure how far legal analysis is going to successfully take us in this, you know, in this direction. Obviously, when one makes comments on a book, one wants to sort of find things that the book has not succeeded in doing, and I think all of those points are absolutely, you know, well made and well taken. I just want to reiterate that this is really the absolute sort of really beginning, hopefully, of a trench of research. And it seems very obvious that, you know, the major contribution is going to be made by Professor Thongchai himself. He can follow up on some of his own critiques. So I'm sort of putting the ball back into your court to say that, well, you know, we look to you as a leader in this field, you know, not only to direct us, but also to provide some of the answers in your own work, as I'm sure you absolutely will do. So yes, it is. I think it's correct to say that this is a bit of a sort of a smorgasbord, and I'm glad that you find that a positive rather than a negative element. I personally don't think this is the point in the development of the field at which you can try to sort of impose a framework of thought on it. So I think the idea is to sort of, well, let's just gradually explore what is there and what people think about it. Where are the gaps? Where are the different perspectives? And I think there are different perspectives being brought. And I would accept the point that some of the chapters could be a lot more critical than they are. Some of them tend to give an account rather than a critical analysis. But I think you need to establish what the actual facts are, first of all, and that's not a straightforward task at all, it seems to me. There's still a lot of archival material, for example, to be gone into. Then you need the analysis from different perspectives, and then we can bring in, you know, the critique of what is going on. And I particularly like what you said about the critique on the basis of the colonial past, because it's always seemed to me, you know, a fairly sort of dumb remark to say that Thailand was never colonized. I mean, this is an extremely narrow definition of colonialism or imperialism, and that whole aspect needs to be got into much more seriously. And I think to some extent, contemporary Thai scholars are not willing to embark on that critique in the way that you have done in your own work. And maybe that's something to be, gotten past, and maybe we can look more seriously at these issues from the past because of their impact on the present and obviously the future. So with those very inadequate responses to the wonderful points that have been made, including by Kevin, also pictures, maps, very, very good. We didn't decide on the font, and I think 700 words per page is quite a lot to take in. But maybe for future exercises we can take those points on board, Kevin. Thank you so much. So with that, I will just hand over to Munin for his comments. Thank you very much.
Thank you very much, Andrew. I just want to add very little to Andrew's responses to the comments kindly given by Kevin, Ajahn Thongchai, and Ajahn Nuthamon. I have to admit that the text on Thai legal history is quite boring and uncritical. But if we look at this edited book in general, we are quite satisfied with the majority of chapters, which provide a critical legal history of particular subjects. And I am also delighted to say that Thailand is entering the new era of the study of Thai legal history, and this book just coincides with this event. And thanks to people like Professor Thongchai. Sorry, it's the weather is really bad here. I'm not really sure whether you can hear me clearly, but yes, it's going to be heavy rain. And so thanks to people like Professor Thongchai and himself and Ajahn Somchai of Chiang Mai University, now so many young people, young academic, are so much inspired to look at Thai legal history from a more critical perspective, and we really need that. And we need a new methodology, a new angle, to look into Thai legal history. I have to say that the almost all Thai legal history is the history of doctrines, the doctrinal legal history in Thailand, and we are now changing. And so I hope that this book will be one of the efforts to inspire academics in Thailand and young people to study or produce more work on critical Thai legal history. So thank you very much.
Thanks very much, Andrew and Munin. I've got two questions that I posed here. The first one is a rather long one, but let me read this so that everybody has the benefit of the questions from. It is from Projai Pintotang. Okay, one methodological issue that pops up to mind during the discussion is whether Thai studies would benefit from the breaking of disciplinary boundaries. Intellectual history also comes to mind as shown to be a very fruitful tool in the study of, for example, the English idea of the ancient constitution. The last related issue is the possibility that new methodologies that employ both legal and historical materials and tools might shed light on Siamese/Thai legal history within the global intellectual context. For example, the extent to which British agents influence Siamese politics, exemplified by the aforementioned intervention by the British judges, and whether this might reveal its connection with what David Todd dubs the Velvet Empire, in the case of French influence outside of the official empire. So that's a question that's posed, I suppose, it's not directed at anyone in particular. So anyone is free to pick this up.
Okay, shall I take this up? I think that's a very interesting question. I think absolutely we need to break down the boundaries between the disciplines. I think that's the entire thrust of what we've been saying for the last hour or so. And I think that raises the question, well, which particular disciplines are we talking about? I mean, obviously, we can talk about history, we can talk about politics, we could talk about economics, we have certainly talked about sociology, and I think the idea of intellectual history is extremely interesting. I would certainly like to see more study on that. I mean, for example, there is the issue of the influence of English utilitarian philosophy in Siam, which I didn't know about until it was drawn to my attention as a thing. And I would like to know more about conversations, leading from Jeremy Bentham to John Bowring to Thai scholars, Siamese scholars, about the idea of utilitarianism. So I think intellectual history, and then of course, one can think about Buddhist intellectual history. I think we'd like to know more about that, the sort of thing that Peter Jackson gets into in his study of Buddha Tat, for example, would be extremely interesting to go into. So I totally agree with the question. I mean, hopefully this work that we've produced would inspire a whole range of people, including non-legal scholars like Professor Thongchai, to engage in this kind of discourse. And as Munin says, we need to open up our legal discourse to wider considerations than simply the development of doctrinal law and legislation. Although there's still quite a lot of interest to be done on that area too, but we need to open that up. So I'm totally in agreement with the questioner, absolutely.
Thank you. I'm going to toss this question at Thongchai, since this is directed to him. You used the term jurisprudence several times, but this is from Suprawi Asanasak from Thammasat, and is asking whether you can elaborate more what you mean by jurisprudence. Where does history end and jurisprudence begin? Or how should we view the relationship between the two?
I don't use it in any special semantics. No, normal. It means knowledge about the law. Right?
Just knowledge about the law.
Yeah, knowledge about the law, the science of the law, something. I use it normally. So where is the history and jurisprudence begin? I can't answer that because I don't think the two related in the sense of one and another begin. So because we can have history of jurisprudence, and a lot of people doing that. I think the relationship between the two, history study the past, history study the change. So the subject of jurisprudence means the knowledge of legal knowledge of legal science can be historicized. And in this case, I talk about Thai jurisprudence. I mean, Niti Sat Kong Thai mean the body of knowledge that form or that are the basis of the foundation of legal system. I in fact, in my draft, I use the word rule of law a bit more, but after rereading Nick Chisman again, he is adamantly against the idea of rule of law to apply to Burma. So I'm not sure I should be more careful or not to talk about rule of law in Thailand. Let's say talk about legal system. It seems to be neutral term. It means, because it means anything. It means so much. Jurisprudence in this case also kind of very broad, very broad.
Thanks. These two questions are directed at Andrew. One from Sarah Bishop at ANU. You've written previously on aspects of legal history. So what's the most significant way the editing of this book has expanded or altered your prior readings of that history? That's the first question. And one from Christian Hofmann about how important this book is. And he is wondering if there may be a plan for a book on Thai private law, explaining more detail the different European influences that have forged Thai private law history. Christian comes from the perspective that doing comparative work on private law is very often difficult because of the lack of sources in English. So actually, I would probably direct that second question to Munin, because you did that chapter relating to the influences on civil law. So maybe Munin first, and then I'll come to Andrew.
Thank you very much, Kevin, and thank you, Christian, for the question as well. Christian, in my chapter, I look at the history of modern Thai private law from legal transplants perspective, and I would also like to respond to the other question posed by Supravi and Nuthamon about the legal transplants approach. I think legal transplants is not, it's not a fixed approach of comparative law. It's not a static one, but it's a mix. It's a mix of different approaches of comparative law. And as I said earlier, that if you look at the Thai legal history work, it is rather descriptive and focused on Thai legal doctrines. Rather than trying to criticize or the traditional Thai legal history. So what I want to say is that if we look from a news perspective of comparative law, if you look Thai legal history, the history of Thai private law from a new perspective, the legal transplants, you will see something new that you will understand, especially for those who really want to understand the problems of Thai private law, and with the approach of legal transplants. For example, if you look at the process of drafting the code, and you see how the code, the foreign provisions were transplanted, were copied from foreign legal sources, and you see how the rules, the English language translation of the foreign rules were translated into the Thai language. You will see that there are so many, with many problems, translation problems, and then you will understand, why, the current legal scholars are debating, okay, on how to interpret the rules, okay. So, but what I did not do much in my chapter, because I didn't have much space to explain is we also need to look at, we also need to evaluate the success of the reception of Thai private law, whether it's really successful from and from economic perspective, from political perspective, from sociological perspective. So that is what Professor Thongchai mentioned, that I wanted other people to look into the history of modern Thai private law from other perspectives, and I hope that we will be able to evaluate, the success of the legal transplantation of the law, modern Thai law from other perspectives. But at least now, I think that we need to start looking at Thai legal history from a different perspective. We need to make it more critical. We should give up, just descriptive Thai, legal history, and that's I think that we just started to do, and I hope that other people will follow.
Thank you, Munin, and I think we look forward to more work coming from you. I know this was the subject of your own PhD dissertation, so this is something that's going to be quite exciting. Thongchai, you have the floor next, and probably the last word, because we're running out of time. And maybe in your response to whatever you wanted to say, you might pick up the comment that Peter Leyland did about historiography, the problems of being shackled with a particular ideological approach to the study of history. I mean, say a Marxist approach and so on, versus, empiricism. Whether we should focus first on getting the facts right, as Andrew keeps talking about, or do we go into it with a particular sort of critical perspective or postmodernist perspective? I think that's the essence of what Peter is trying to suggest. So Thongchai, over to you.
I raised my hand. In fact, I like to talk issue that Munin mentions, transplantation. In a way, Thai legal history pretty much talk about transplantation, which is the fact. I mean, we can't deny it. What I wonder is there seems to be minimal friction. That one is, I suspect, I don't believe that. But again, I don't know enough to say it, just curious to know. And once I read, I have to say that among during the few years that I entered this kind of field, my attention is more to public law. I didn't know much. I never trained in legal studies. So I found your article and the other one on trust. Amazing. Amazing and curious, because hard to believe that, wow, the whole process just translating and copy and without much friction with traditions. That these are the issue, but my take of those articles is that it's hard for me to believe, but it's amazing, it's quite interesting. If Thai law use those methods, wow, how could it survive for 100 years? That kind of thing. If it's true and survive 100 years, in itself is an interesting question to find out how could it survive 100-something years just because result of copying and translation. Peter Leyland, well, I'm not sure I understand your question, so I will answer as much as I understand.
It's more a comment. It's more a comment.
Yeah. I'm not sure I understand his comment. As much as I understand, I would answer, don't worry. As long as anybody analyze anything, offer any frame, make it clear, don't hide it, right? Then other people can criticize. And if even better, if the person use whatever method, whatever concept, he or she should see his or her own limitations. Don't hide it, declare it, make it clear. Doesn't have to be declared directly, but let's say, don't try to hide it. Make sure that the reader knows what you think. That's it. Then we can be criticized. Other people can supersede that. Other people can argue from different directions. That's all.
Well, thank you very, very much, Thongchai, for that. I mean, the debate goes on, and I think the work on Thai legal history will go on. Let me, on behalf of the Center for Asian Legal Studies, thank our editors, Andrew and Munin, for your presentation and giving us a wonderful book, and to our commentators, Nata, Thongchai, as well as our wonderful audience who have spent the afternoon here with us. Thank you very, very much. We hope to see you again in the next virtual roundtable on Asian law. In the meantime, please send us some feedback using the QR code or the web link, the URL given on the screen. So once again, thank you very much and have a great day.